Good afternoon, everyone. I'm Stephanie Anderson. I'm the Probation Foster Care Specialist at CPOC. And forgive me, I have progressives. I've only had them for about 2 weeks, the glasses, so I'm really trying to adjust distance and reading off my thing here. So anyways, I just want to thank you so much for joining us today. Just a couple housekeeping items. There should be some handouts in the back. Also, there's additional resources. You should have received an email with the handouts, but also you can go on our website. They're there as well. Multiple resources besides the handouts. So just wanted to share that with you. Also, if there are any questions that you have, there should be some index cards at the end of the table. So if you want to fill it out, raise your hand. I'll grab them and take them over to Mary Michael and Joan. And then also, it's what I've learned from our last session is that you are able to project your voice loud enough. We should be able to hear you because it's a small room. So anyways, we'll go ahead and begin. This session is called Navigating the Court Process under Family First Prevention Services Act Part 4. As you may know, the implementation was in 2021, October of 2021, so it's been a little bit past 6 months since we've had this implementation, and we thought that it would be great to actually have, there's a lot of lingering questions, things that always take place, or lessons, we're learning as we go through the implementation, right? So it was a pleasure to have communicate with Judicial Council and Mary Michael and Joan, and they had offered to present and also just to cover the court-related process as it relates to Part 4. Also, it includes the permanency as well, so they'll be capturing that more at the tail end, but the main focus I want to say is more of what does this process look like as you are trying to have a youth go into an STRTP. So we have our subject matter experts over at Department of Social Services that will also be assisting us if there's any additional questions that may be had. They'll be here as well to help answer those questions. So I guess from now, I'm going through here, sorry, once again, looking through my glasses and trying to wing it because I can't see everything. I'll go ahead and start with introductions. I would like to introduce you to Mary Michael. She is the supervising attorney over at the Judicial Council of California. And then also we have Joan Tillman. She's the attorney at Judicial Council of California. So I'll go ahead and let you guys take it away. Thank you.
Great, thank you, Stephanie. I have a tendency to speak fast, so if you need me to slow down, just tell me. I won't be offended at all if you just tell me to slow down. As Stephanie said, my name's Mary Michael. I'm a supervising attorney at the Judicial Council. I supervise about 5 different attorneys, and we go all around the state. You probably know us. It's Joan and Beth and Dan and Karis. If those names don't sound familiar or you don't know who your Judicial Council attorney is, let me know and we'll make sure to hook you up with them. So just as a preliminary matter, who knows what the Judicial Council of California is? Can I get some hands raised? Okay, a few of you. We're not very popular or big. The Judicial Council is the policy-making branch for the court. So all of your rules, all of your forms, if you have a problem with your judge, let us know. We are the people that can talk to them and help you through some issues that may be occurring in your county. But rules, forms, court process, that's sort of all of our bailiwick, and we'll be talking about some of those today. Another real quick thing before I turn it over to Joan to introduce herself. Can I see how many people have been a probation officer for like 5 or less years? Okay. 10 to 15 years? Oh, did I miss 5 to 10? 5 to 10 years? Okay. 10 to 15? 15 and more? Wow, okay. We've got a lot of experience in this room, and I really hope to learn from you because I haven't been around that much. I mean, I'm pretty old. I've been at the council for like 13 years, but you guys have been doing the work. And, when we try to implement things at the court system and the court level, we need to know what's going on at the local level so we can help you. We don't want to hurt you. We don't want to hinder you. We don't want to make things harder for you. We want to help you with the court practice. And that may mean that you're disagreeing with maybe what your judge says, and that's okay. We're there to mediate issues as well, but we do really want to help. So I'm going to turn it over to Joan now to introduce herself.
So Mary Michael has a wealth of experience. She's underselling herself drastically, and I'm very privileged to have her as my boss and up here. Just so you know a little bit about my background, I was a DA for many years. I represented kids in juvenile justice for many years. I've been a dependency attorney. I've been a CASA. I've been a resource parent. I've been a foster parent for a period of time. And I will tell you, and Mary Michael will back me up on this, probation is near and dear to my heart. Because I feel like a lot of 602 kids are just 300 kids in different clothing. So, and I know that all of you feel that way. That's why you're here at this foster care conference, because you want to learn more about the options and what's happening. So can I get a show of hands of who's super excited about learning about short-term residential treatment programs at 2:45 on Monday?
Woo,
Wow,
one
nobody's
person.
raising their hand.
Nice.
Okay, so Mary Michael and I are used to walking around when we do training, but we're kind of hamstrung a little bit here. But when we start doing questions, I think we'll kind of sort of break free and get permission to go down there and meet with some of you. And if you're uncomfortable because of COVID, we can stay away and, you know, do our thing. But Mary Michael, why don't you go ahead and lead us off?
All right. First of all, I'm very short, so being this tall and overlooking people gives me a little bit of sense of power. I'm not going to lie. Okay, so today what we're going to be talking about is explaining the court process as it pertains to FFPSA. We're going to be looking at some hypothetical situations. I was told not to make them easy, so they're a little bit hard. And then we're going to talk about explaining some permanency options for youth when they're leaving care, because I think it's, as kids are in STRTPs and they're transitioning out, we have to start thinking about what that looks like for them, and what the legal options are for our families, for those youth. And there's a couple different legal options that we'll be talking about. Okay, so the starting question: why does the federal government believe that we need the Family First Prevention Services Act? Any thoughts? No. It's all right. It's only 2:53. You'll get warmed up.
How about you take some guesses? Why do you think the federal government thinks we need FFPSA? Because we need more statutes in our lives? Because we need more forms to fill out?
We need a whole new court process.
Just shout it out.
They don't think we're funding or reuniting them quick enough?
Okay, so you think they don't think family reunification is happening quick enough?
Correct.
Okay, that's a great answer. Anybody else?
The system that we have right now is just not working.
Okay. The system we have right now is just not working.
Yeah.
Monitoring children or youth or placed in the that don't need that level?
So monitoring children that are in, can everybody hear everybody? I don't want to keep repeating it if you can hear everybody, but monitoring those kids that are in long-term care that may not need it,
That level of care.
that level of care. How about money? Okay, I get in trouble if I talk about money, so I'm not really talking about money, but you should be thinking about money a little bit for your counties just to make sure that you're satisfying all your Title IV-E obligations.
We're going to be talking about money a little bit. Okay, so the purpose, so first of all, California didn't believe we needed FFPSA either and tried to stop it like twice, but the feds thought we needed it. So their purpose under federal statute is basically to enhance supports and services for children and families and ensure, like the gentleman said in the back, the necessity of placement to make sure that this is the level of placement that the child needed. And that couldn't be met in a lower level setting. And then in California, you can see sort of what the legislative intent is for us, which was sort of to develop systems of care to build trauma-informed services and community-based settings, and roadmaps for short-term and long-term strategies and interventions to help these youth. So that's basically the premise on the federal and state level of why we needed the Families First Prevention Services Act.
So how many of you have actually done a placement after October 1st, 2021 in an STRTP? Raise those hands up high and proud. There you go. Okay, congratulations. A lot of probation officers have not done them at all. What I'm going to tell you is the same thing I tell my counties when I go out to train them is this seems daunting. It seems like there's a lot of forms. It seems like there's a lot of requirements. However, in a couple years, it's going to be just like AB 12. Remember when AB 12 came out and we were all like, oh my gosh, how do I do this? I don't know what to do. And now we're just like, yeah, we got this. Okay, and that's how you're going to be about FFPSA pretty soon. But who can tell me when, this is a multi-choice.
No, we're not there yet.
Oh, we're not there yet. Okay, sorry.
It's all right.
We're not
Jumped
there
ahead.
yet.
It's fine.
I'm just overly enthused, I guess.
I just wanted to give you a little bit more background before we jumped into substance. So FFPSA, like Jen said, is about funding, right? Federal funding, how to get federal dollars. And basically what the federal government said is we don't trust that these kids are getting court oversight. We don't trust that this is the level of care that they need. Now in California, we had continuum of care reform, so we already had this huge system in place to ensure that this was the level of placement that the children needed, but other states didn't. So what the federal government said is we want to add a court oversight piece to kids in this level of care. So it's a cost-neutral bill. So FFPSA has 8 parts. We're going to talk about part 4. But basically what that means is that the federal government was saying, okay, if we have less kids in congregate care settings in these STRTPs, then we can use that money for prevention and have less kids in the system, right? So in their mind, it's cost-neutral because we're preventing kids that don't need it into these STRTP placements, and then we're able to sort of take some of that money and put it on the front end. We'll see, right? We've in California have had it for 6 months. Other states were early implementers, but California is the state that pulls down the most $40. So we'll see if they're right. But 4E, or FFPSA, created new court requirements. It required a QI assessment, so a QI is a new person to play in our sandbox, and we know how welcoming we are to new people playing in our sandbox. So we're gonna welcome them with open arms to come in and help us. It required a new court hearing. Some of you call them STRTP hearings. Others call them 45-day hearings, but it's a new hearing to talk about the STRTP placement. And then it has new case plan requirements, and we're gonna be talking about all of those as we move on. And so now I'm gonna give it to Joan to do
Oh my
her
goodness, I
piece.
jumped the gun once. Okay, all right. Ooh, she's even giving me the clicker. All right. I'm gonna let you hold the clicker, just because. I'm gonna give you a multi-choice question right here, and there could be candy involved for somebody who gets it right. And then we're gonna play a little game at the end. It's not tremendously huge. Mary Michael doesn't really like games, but she's letting me do it anyway. But when does the FFPSA court process begin? When the kid is arrested, at the time of detention, the detention hearing, when they're made a ward of the courts under 602, when they're placed into foster care, or they're actually placed into the short-term residential treatment program. Who wants to take a stab at this one? B is an answer. It is.
Yeah, go ahead.
Does anybody want to take a different stab?
Yep, she's got it over here.
Oh, there you go.
E, we've got an E.
We've got an E and
Anyone else?
E.
E.
How many think B? How many think D? Okay, you can't do E and D. Oh, you said D. Oh, I apologize. I thought you said E. And how many say E? Okay, like at least half of you didn't vote, but we'll move on from there. Okay. It actually is E. It's when the kid is actually placed in the short-term residential treatment program. And the main thing that we need to stress at this point is there shouldn't be that many kids going STRTPs these days. Okay, look at the requirements. The requirements are basically that they have to have some, significant mental health issues, not just the kid's a pain in the you-know-what and we can't find a placement for him. And we'll talk a little bit about that, about how not having a foster home is not good cause to put a kid in an STRTP. But to go to a short-term residential treatment program, you have to remove custody from whoever it is has the legal custody, whether that be a parent, whether that be a guardian, and the kid has to be placed in foster care, which means you're under the care and custody and control of the probation officer, and the placement decision is up to you until it's not, until a judge reviews it and then decides whether they agree with your assessment and the QI assessment, which we're going to talk about in much more detail. All right, so let's talk about some common issues in determining removal from custody. What if we don't know where those parents are? What if the parents are AWOL themselves and we don't know where they are? What if the kids have been living with relatives and there's no guardianship in place? What do we do? And what if relatives say they are the legal guardian, and they've been acting like the legal guardian, but there is no order?
Are these common? Do you guys see these? We're gonna get there. We're gonna get there. Are there any ones we're missing? These were the three most common we could think of. Are we missing any?
What do you guys do to find parents? And we're going to talk about parentage in a little bit, but I want you to think about what your county does in finding parents, even in 602 cases, as the case progresses, and we'll talk about why that's important. All right, so we're going to talk about all of these things, and after
Oh.
Mary Michael gives us some more background on FFPSA.
I think we have the wrong
We have the wrong order.
PowerPoint.
I think we do too.
Do you have your,
I do.
hold please.
Well,
We're
I
gonna
mean,
have a little technical
we can
interlude
we can just talk.
between now and that.
Okay.
One of the reasons why we put some things in the PowerPoint that we thought were better to discuss than just
So
going
we're
back
going
to
to have some
FPSA.
technical assistance, hopefully, and maybe we can just bring up the PowerPoint on this flash drive?
Yes.
Yes.
We do.
So we actually amended our slide presentation afterwards because we thought of some other important concepts that we wanted to consider. And while this nice IT superhuman is coming up here to put this in here, we're going to talk about family reunification. Somebody asked me today, when I first came to the session today, if you could give one piece of advice to probation officers, what would it be?
On
What's-
family reunification?
Yep. What would it be? What do you think? How about something in your probation report about family reunification? We review probation reports from all over the state, and a lot of times family reunification efforts are completely missing from the probation report unless they are in a very therapeutic STRTP that does a lot of family counseling or a lot of individual counseling, and then they will include that in there. Let me ask you another question. If the kid is a crossover from dependency and the parents have exhausted their services, they've run their course, they've done their 12 months or their 18 months, and they're done, and then they get transferred over to 602 land, do you get more services then? Who thinks yes? Who thinks no? Who's the other 47,000 that are not voting in here? Okay. There is no candy and there are no prizes for people who don't participate, just FYI. So the short answer is no. You don't start over. You don't start over again. Because kids need, what's the P word? Permanency. I love it. I love the fact that you guys came up with that right away. I always tell when I do my training, I'm like, if you don't remember anything else I say, just remember permanency. So, because kids need permanency. They don't want to be hanging out in juvenile hall. They don't want to be hanging out in some STRTP. They want to actually have a home, like the film this morning with Jethro, and that was just amazing that they took these older kids in and what they did with them. The other thing sometimes we see when we go to counties is that every report from probation is a permanency report, okay? So one of the things we want you to think about is what post-permanency means. So post-permanency is after parental rights have been terminated, which can happen in a 602 case, just like it can in a 300 case. It doesn't happen very often, but it does. Or if the parent has said, I don't want reunification services. Somebody else I talked to today told me they had a mother who, as soon as the kid became a 602, they took off and left to go to Mexico. They just said, peace out, we're done. So a lot of times there's a waiver of after reunification services or reunification services have run, like they have in dependency or delinquency. Post-permanency is any time services are terminated for whatever reason, whether it's because of waiver, whether it's because the time has run, whatever it may be. And why do we make this big deal about permanency versus post-permanency? Because what happens when you switch from permanency to post-permanency? What are you looking at? What's different? I heard it from somebody. Case planning goals. You're thinking about what's going to happen with the kid. You're shifting. Your mind is shifting over to what's the long-term plan for permanency for this kid. We're not going to wait around for mom and dad forever to get their you-know-what together. We're going to try to get some permanency for this kid. All right, one other thing that we asked our colleagues on the JIRTA team, like, what would you like us to talk about with probation? And they said the date of entry of foster care. Okay? And why is that an important date? Why do we care about that? Come on, let's hear it.
It's when the clock starts.
Clock starts, funding, somebody else said something else. Okay? Because exactly, the clock starts from the first time of the date of entry of foster care, which is, it's different in 602 cases than it is in 300 cases.
Does anyone know the definition of the date entered foster care in probation cases?
Slide 10.
Take a guess.
Should be. Oh, there, okay, one more. Wait, back one. Back one.
60 days from the date of removal, or
Yeah, it's perfect.
it's the date of placement if they're in the ranch, camp, or hall for more than 60 days. Or, one more. What if they come from dependency? Dependency date of foster care carries over. You don't get a new date of foster care when you come over to the 602 side. So your date entered foster care comes over with you. So if a child's in post-permanency and dependency, like Joan was talking about, they're now in post-permanency in juvenile justice or delinquency because it just comes over. So in dependency, 300 land, we have one date entered foster care. In juvenile justice, you have one date entered foster care, but 3 different definitions of what that could mean. So it's either 60 days from when the child was removed, date of placement if the child's been in the hall, ranch, or camp for more than 60 days, or the dependency date.
Okay, next slide.
Okay.
So those are the ones that Mary Michael just covered. And the reason why we care about it is that's what determines how long family reunification services happen and what happens permanency-wise for the kid. So I just threw out some examples of FR services while a kid is in an STRTP. If your clients are not getting the services, they ain't in the right place. All right? So if your kid needs to participate in family therapy and the STRTP doesn't offer family therapy, is that a good fit? No. Okay? If they need individual therapy for anger management and the STRTP doesn't offer that, is that a good fit? No. And that's why we're going to talk about how this all ties into QI stuff. One other thing that's near and dear to my heart, which I don't see a lot of in probation reports, is reports on sibling visitation. Okay? Because just because they're not going to reunify with their parents, their brother, their sister, their half-brother, their half-sister, their cousins, whoever it may be, they want to keep in touch with. They want to have that visitation. They want to say, this is my family. Okay, the only other thing I want to emphasize with this, Title IV wise, and then I'm going to turn it over to Mary Michael again. What's the term that we use all the time and what kind of efforts we have to use in child welfare or probation cases towards family reunification? Reasonable.
Reasonable
Reasonable,
efforts.
unless you're 16 or older. Then what do you have to do? I'm going to be so impressed if somebody knows the answer to this. I'm going to die.
It's on the screen.
Oh, somebody over there, I saw it. Somebody raised their hand over there. I'm looking at you.
That's right.
There you go. Okay, see? I know it was like a gimme, too. And you were the only one that was willing to raise your hand. Ongoing and intensive efforts. And why is that? Because older kids want permanency, too. Older kids want to be adopted. Older kids want to be in a guardianship. Older kids want to be with a relative. Older kids want to be with a NRFM that they can stay with for a period of time that they have that bond with. And what the federal government when they come do our Title IV review, is they say that California does a lousy job with permanency for older kids. Right? Because it's too easy to say, oh, you know, he's not a cute little baby anymore, and I don't know if I'm going to be able to find a home for them. That's when you try even harder. That's when you do what those RFA parents did this morning, and you keep going back to the well and hope it doesn't run dry in the meantime. Oh, okay, I guess I have one more, and then it's you.
Yeah, and the one thing I'll say about the intensive and ongoing efforts, this came from the 2016 Federal Act, Preventing Sex Trafficking Act, that required for our applicant kids or kids 16 and over for this to be the reasonable efforts finding. It's not just case planning and reasonable efforts, it's ongoing and intensive efforts. And it's really hard to see when we review reports what's the difference between reasonable efforts and ongoing and intensive efforts, but there needs to be a difference, there needs to be a distinction. In my mind, that's more family finding and more, trying to engage the child and community, and trying to sort of do more permanency efforts for these older youth. There's a reason why the Fed said we have to have more efforts for older kids than younger kids, because they're seeing these kids age out. That's what's happening, right? Or they're seeing them choose NMDs. I'm choosing extended foster care. And just because they're going in extended foster care doesn't mean that they don't want permanency. They don't want that connection, that lifelong connection that they have with someone that they can call at 3 o'clock in the morning when they're stranded on the side of the road, right? As parents, or as me as a parent, I would hope my child would call me if they were stranded at 3, but I think about some of our foster youth and I don't know who they would call, right? We want to make sure that we have that connection for them so that they feel connected to someone who they can, call, who will come help them if they need it.
So really quick, because this is not a Title IV training, but it is an FFPSA training, which we're going to get to. Just real quick, here is the dependence delinquency timeline. It's actually in your materials, and we did change the PowerPoint. CPOC is going to post it on their website, and we can also email it to any of you that you would like. But basically, it's just what's the period of reunification, and when does the court have to do stuff? Okay, so at detention, there's 3 findings the court has to make that are Title IV findings. Continuance in the home is contrary to the welfare of the child. Temporary care and placement is vested in the probation department. And the third one? Reasonable efforts have been used to prevent removal. Exactly. What do you guys do to prevent removal, reasonable efforts wise? What kind of strategies do you use?
Wraparound?
Wraparound?
It's a good
Great.
one.
Okay. CFTs? Excellent.
I know there's been a lot of new prevention programs or diversion programs that have been coming out in the last couple years, so I'm excited to see those and how they affect. Of course, there's some that you're not going to have reasonable efforts, right? You're not going to be able to do it. The situation is too emergent. The child was arrested on a serious offense, and that wasn't going to be able to happen. But to the extent that they can happen, all that work with the family pre-petition or pre-foster care is going to help you with those family connections and hopefully limit the time the child needs in foster care and make sure that we know what services they need when they get there.
It also helps with limiting the time that the kid's in juvenile hall, he's in detention. So in a recent county visit I did, they're significantly, the defense attorneys would make motions to modify custody status. If the kid's doing well in custody and he's got someplace that's safe for him to go, do we want him in juvenile hall? No, we don't. We want him out, and we want him with hopefully family if we can make that happen, or somebody safe. Okay, we're up to questions. Does anybody have questions right now? No. Okay.
Perfect. Bring it on up.
Give it to Mary Michael. She'll know the answer.
I feel like, is it The Price is Right or whatever that show is? In addition to the court, do the parties also receive a copy of the QI report and the case plan? We will be getting to that, but the definition of parties is not in statute, it's in our rule. So we will talk about that. We will also talk about additions to parties in the rule based on some things we might have left out the last time. We're not perfect, just saying. So just hold that. If I don't get to it when we get to that section, just let me know.
I have a question.
Sure.
So I'm on the CFS side of the house.
Okay.
Not on the probation side of the house. So if
Sorry, I have to
we
stand.
have a QI that says family days and our side of the house is still thinking STRTP is appropriate, and actually the judge agrees, that's a really sticky situation because Title IV still funding goes away, correct? That's how my count is interpreted.
Correct. So if anyone disagrees, and my understanding is that if anybody disagrees with the STRTP placement, then the funding is not available for
You know, there's
federal
certain
funding.
Rules on it, so you have to place the child there.
Right.
Or you don't get funded.
You don't get the federal funding, is that right? I'm looking at Lisa because they're our they're our state partners.
Give 30 days from the date that the QI makes the determination for family-based, you continue federal funding for that 30 days, but after that point, there wouldn't be any more federal
Right,
dollars.
but you can't go against the court rulings, you can't pull the kid out.
Correct, yeah. That would probably not be a good idea. It's very sticky, and another sticky question that we got that we don't know the answer to this last week was kids that transfer in, where the court has put them in an STRTP versus a QI, and it's already county funds, and then they transfer into a new county, and what that looks like. Don't know the answer to that question yet. Yeah, go ahead.
A similar question, regarding the legislation, if I'm using the terminology correctly, but if there's a recommendation, and I'm on the behavioral health side, so one of the QI assessors, but if there's a recommendation for a family-based setting and it's a specialized home, and you meet that 30-day, or that 30-day marker comes up in the court, and the court orders you don't want to apply that, is there wiggle room in terms of, you know, an additional time period to allow our children and family services partners to locate that specialized home that the child and family team along with the QI has recommended to reduce, ultimately to reduce recidivism, right? 'Cause that's
Right, so the child's already in an STRTP, and the QI has said they don't need that level of care,
correct.
and everybody agrees they don't need that level of care?
Correct.
Okay.
That's a specialized family.
Right, they need a
It's little
specialized
more-
family placement. Yeah, so, I don't exactly, I'm gonna maybe ask my state partners to do that. What I will say is that it's not gonna be funded through FFP for more than 30 days, but I can't imagine taking the child and putting them in a shelter and then putting them in a specialized setting. I would think that you would keep the child in that setting until you found something else. I know there was a case that just came up last week that we heard about where the kid's been there for 90 days after the QI had recommended another setting, and they just can't find
But
an
if-
appropriate setting.
I'm sorry, but if the judge agrees with that family-based QI, doesn't that impact?
It does. So they have 30 days to transition the child, but if they can't transition the child without 30 days, I doubt anybody would want this child to go to a shelter or something else in the meantime. I guess they would, I don't know, Lisa, I'm sure they would like work with the family until they found something, right?
Yeah, I mean, that could be a good time to have a technical assistance call with the state if you haven't already done that. Or to meet with your interagency placement committee or your interagency leadership team to try to come together. We also have some options at the state, like Daily Solutions. We have a contract for child-specific, like social media type recruitment efforts. And so if you contact us at the state, we can help with some of those resources. But yeah, we definitely wouldn't want to see kiddos transition to a shelter as a transitionary step. We'd like to support you in finding that appropriate home-based care.
And I was just gonna say that the third, you know, if it goes against the QI or even if it's different past the 30-day, it would just come out of county expense. It doesn't mean that they have to go to a shelter, it just would be out of local dollars.
Yeah.
So one other question, when does the 30-day time period start? I've heard two things. One is when the QI is actually submitted, like the day they sign the paperwork and give it over to the court, but if the court hearing hasn't happened yet, and actually the worker doesn't even know it's done, or is it the day of the court hearing?
That's a really good question. In my opinion, it's the day when the court makes the decision, right, the order.
When the court makes the,
I mean, you wouldn't know beforehand, right? If the court agrees with the QI, then that's one thing. If the court doesn't, then that's another thing. But you're not going to know until the court actually makes a decision. So I would say the 30 days to transition would start from when the court makes the hearing. Of course, you might have a QI assessment that's been done really early on before the.
not our, not.
Okay, so sometimes I think the way it's supposed to work is the QI is supposed to be done even before the child's placed, and if that happens, right, hopefully the child wouldn't be placed in an STRTP, but if that doesn't happen, then it would be the date when the court holds the hearing, and then 30 days from there.
Yeah, and I think it is 30 days from either potentially,
Oh.
right? Because if the QI says family-based, then you've got 30 days from that determination. And if the court, if the QI says, oh no, STRTP makes sense, but the court disagrees with that, then you have 30 days from there. So you do have two different
Wait a
timelines.
minute, I'm sorry, I was writing something down.
So I think what she said is if the QI says family-based, regardless of what the court says, you've got 30 days.
So the time clock starts when they sign it, nobody knows. When does the clock start? That's what we're
Probably
trying to
when
figure
it's
out.
served to the agency. So when the QI actually serves it on the agency or gives it to the posting agency, that would be your 30 days.
So it's
So
not,
there-
so that's 2 weeks actually before the court hearing.
So there are two different dates. So if the QI says family-based, you technically have 30 days from that determination to receive FFP.
So,
Right. I mean, we're here from the court process, so like, it sounds like if the QI makes a determination that it's family-based, then it's from when that determination is given to the agency. The court can always, the court can agree with that or not. So, you know, if the QI says family-based and the court says STRTP, then that's not gonna be funded anyway, and the child stays in a STRTP.
okay, but before we go too far down the rabbit hole, just let us get a little bit more out, and then these are all fantastic questions, so we can start addressing those
Okay.
directly.
I was told I have to sit down. All right. All right, I'm gonna try. As you can see, I'm a little bit of a wiggle worm. Okay. Apparently, we're going back to FFPSA because all these are great questions, but they're all sticky, right? Because this is a little bit sticky. Okay, so just some fundamentals for FFPSA. The federal rule, if you ever want to look at the federal statute, it's 42 USC 675 AC, which is what sort of talks about the court process, the QI, what it needs to have, all of that stuff. The Welfare and Institutions Code, 727.12, and the Rule of Court, 5.618. Okay. Let's talk about the new person in our sandbox, the qualified individual. So the qualified individual is someone who basically is there to sort of look at the file, talk to the child, talk to the CFT, and see what the needs are of the child and whether those needs obviously can be met in a family-based setting or if they need the STRTP setting. And it's sort of, they're a licensed professional, right? They have their own license. They have their own understanding and background of mental health and mental health services. And so they're really a specialist in this area. So we're looking at, you know, we have the IPC and we have the QI, right? And sometimes they're going to agree and sometimes they're not. And sometimes the QI and the CFT will agree and sometimes they won't. But it's sort of a second pair of eyes, right, on the kid and on the family to see what happens. And so whenever we have a new person in our court system or, you know, invited to the dinner table, right, the rules are going to change a little bit. Who gets information is going to change. What information that they get is going to change. And so we're going to go into that a little bit. If it's an Indian child, the QI is sort of like the qualified expert witness in an Indian case. So the qualified expert witness can be deemed the qualified individual if you have an ICWA case or a native child.
Is that only if it's an Indian qualified individual?
Yes. Yes, thank you. And then, let's see, what else do we have? We have the new court hearing within 45 days, which we're going to get into, and
It's really
makes sense.
60, just so you know.
don't tell them that.
I know, well, I'm a realist.
Okay. So the new case plan requirements, oh wait, this is you.
Yes, yes, it
Okay,
is.
go ahead.
So what do you have to do as a probation officer that you didn't have to do before? A lot of this is duplicative of what you've already done in the past when you've done your probation reports. But we're going to play a little game at the end about CFTs, but your job is to figure out who should be at the CFT. Who does the kid want there? Who are the most important people to be there? Who are the people that should have input on what happens with this child? You need to contact other people that don't want to come to the CFT. I want to tell you what I think should happen with Johnny, but I don't have time to go to the CFT meeting, and I don't really like the people there, and I don't want to be there, and whatever. So, but I want to give you this information about Johnny because Johnny's important to me, okay? That's your job too, is to gather that. This is actually another little gem. You have to have a CFT when people can actually be there. So I can't even tell you how many CFTs I went to at 7, 8 o'clock at night because the parents worked. And that was the best time for them, or the kid had after-school activities, and that was the best time for them. If reunification's the goal, then the parent gets to provide input on the CFT members. The evidence that the QI's determination was conducted by looking at the CFT. This is another fun area that we don't really know the answer to, which is when does all this take place? When does the CFT take place in relation to the QI assessment, in relation to IPC? And we're all just struggling along through that because of the strict timelines that we're going to talk about in just a couple minutes. How about the placement preferences of the kid and the CFT's relatives, where they want to be? And if you're going to end up recommending something different than what the QI said or the CFT recommended, mainly the CFT, you have to put why in your report. Well, because my client has a really bad alcohol issue, and this is the best alcohol treatment program for teens, and I was really lucky to get them in this program, and I think they're going to succeed because of X, Y, and Z. Put all that in your report, okay? Because that may be a good reason. But we normally want kids and parents and the people that are important to them close together while they're going through an experience like this.
And so what I'll say is we've had CFTs for a while now, right? But we haven't had to put them in case plans or court reports, right? You've been doing them, but you haven't had to document them and put them in. So this is new. Now it has to be in the case plan, and now it has to be in the court report that this happened. So you'll get us, me, Joan, Dan, Beth, Karis, Jenny, someone, looking at your court reports and saying, is it there? Do we have the evidence in the court report for the court to decide, if the CFT and the case plan, if the case plan meets the requirements based on the meeting with the CFT?
And if it's not in the court report, the judge does not know by osmosis the efforts that you have made. So I was in a county recently where they said, well, don't you review all of our notes that we have and the probation file and all the relative finding we did and all the rest of that stuff? The only thing the judge sees is the court report. They're not coming and look at your probation file. That's what we look at too. We look at the court report, we look at what's included in there and what documentation is included. Okay, so let's talk about time frames. Really, there's only 4. Okay, once again, I'm going to tell you, we're going to simplify, so this is a lot easier to just wrap your mind around, okay? When do you have to give the court notice that you've placed the kid so that they can actually set the hearing? 5 days, okay? When is the court hearing supposed to take place to approve that? 45 days. It's really 60. Okay. But the reason why we keep emphasizing 45 days, even though I'm joking about it, is because what if there's a contest? What if the judge says, I need more information about the placement? What if the kid wants to be at the hearing, but something's happening in their life so they can't be there at the hearing? Okay? That 60 days that I keep whispering about, that's strong. That ain't going anywhere. You don't get that placement approved by 60 days, then you're not getting Title IV matching funds for that placement. Okay, 7 days, 10 days. 7 calendar days if you're going to have a hearing. 10 court days if you're going to ask without a hearing. So one of the questions I've been asked as a JURTA is, well, what if the kid took off from the placement before the QI could even talk to them? And then the QI says, well, I couldn't finish my assessment. So as I used to say when I represented kids, they vote with their feet, okay? Kind of assume they're not really one with the placement if they're left, okay? If they're not there anymore and they're not participating anymore, okay? That is one factor for you to consider, and that's one factor for the court to consider. And once again, we're going to play a little game at the end about AWOL youth, too. Okay. All right, next one. Placement is made. What are the service requirements? Okay, we just talked about this. You got to request a hearing of the court within 5 days of the placement. That is so. I'm going to tell you a little secret that even Mary Michael doesn't know. Shh, don't tell her. Before I came to the Judicial Council, the words mandatory and optional at the bottom of those forms didn't mean a whole heck of a lot to me, okay? Because I was just excited as a practitioner when I saw there was a judicial council form. I was like, thank the Lord, I don't have to reinvent the wheel and do this again. So what I'm going to tell you about judicial council forms is they're mandatory unless they're not. Okay? So 4 out of the 5 forms are mandatory. You have to use them. And Mary Michael in a couple minutes is going to talk about some upcoming changes that may happen, but they haven't happened yet. Okay, so 4 out of the 5 are still mandatory. I see you laughing back there. So what's the only one that's not mandatory?
The notice of hearing from
Notice
the
of
court.
hearing, right, okay.
The court's notice of hearing is not mandatory. It's
Exactly.
optional.
And I would notice you're not giving anyone candy. I'm just gonna.
I was
point that
gonna
out.
pelt
Okay.
them at you, but I thought that would probably hurt someone.
She thought that would, yeah, she thought that
so
might get us in trouble.
Apparently
So,
I can't stand.
There you go. Okay. Well, you can stand and throw candy. You just can't stand and actually continue on talking about FFPSA, apparently. Okay.
I'm trying to be good.
All right. So the notice of hearing is not mandatory because a lot of courts do stuff by email. Small courts do stuff by telephone. The court just calls you up and says, we're going to have a hearing on X day. Welcome to my courtroom. I'm the king or queen, and I get to make the date, and here's where you shall be. Okay? You got to serve. Okay, so there's a little confusion about the proof of service. How many times do you have to serve people with documents before STRTP hearings? Uno or dos? Dos. Correctamundo. Okay. I don't even know if that's Espanol, by the way. You have to serve everybody with the notice of hearing and a blank objection form or input form, as they call it. And then you have to serve a proof of, you have to file a proof of service that says, yeah, I gave everybody the report with the QI assessment. Okay? Social worker must serve on CASA as well, but not probation officers. So that's one of those little things we're going to clean up. So right now, the statute doesn't require that the probation officer be served, or the DA. And Mary Michael's going to talk about the proposed change to that. Okay. So let's talk about fun, festive, mandatory forms. All right? The first one is your placing agency's request for review of the placement. Why do we want judges to review placements? You're the probation officer. You know your client. Why do we care what the judge thinks? Why? Somebody give me some good answers. Okay, funding, I know, when in doubt, funding, right? When in doubt, funding. So and there are Title IV findings that have to be made, which we'll talk about in a minute. Why else? Because the judge, oh, wait, somebody.
I was going to say it demonstrates to the feds that we have that judicial oversight.
Exactly. That's a huge part of it. It's also that we have judicial oversight over placement. It's also that a fresh pair of eyes is looking at that placement and saying this is the right place for this kid. Okay? Just like what the QI is doing. Okay? Okay, JV 235, service requirements. I just went through this, so we're not going to go through it again. The JV 237 is the proof of service. Once again, you have to file how many of those? 2. Is it a mandatory form? Yes. Okay. And what happens if you decide you want to get your hearing, you want to get your STRTP placement approved without a hearing, and somebody objects? What happens then? Somebody said it. The hearing's what?
Still required.
The hearing is still required, exactly. If somebody objects, once again, kid walking with their feet, mom or dad, too far away, I don't like this program. The attorney for the kid, because the attorney, the kid's telling the attorney, I don't want to be there, I don't want to do this, okay? All right, JV 238, which is your notice of hearing, that tells everybody when the hearing's going to be. Is that mandatory? No, it's not. That's the only one that's not mandatory. Good job. Okay, and now, Mary Michael.
It's my turn.
It's her turn.
So when I asked you what the Judicial Council does, we really just make rules and forms. Actually, the Judicial Council is constitutionally mandated to make rules and forms. It's part of the Constitution and what we are required to do. All right, so we're going to talk about the hearing report. So how many of you have had a QI assessment and a QI hearing? Can I see the raise of hands again? Okay, so about half the room. Okay, so the QI assessment, what it says in the code is that the copy of the QI assessment determination and documentation is required, and the CDSS has created a template to be used, which I think may be changing, may or may not be changing, but there's a template for the QI to use to provide that information to the court. The statute itself didn't address any confidential information, and I know that this is a sticky thing, right, about what's confidential, what's not. We're not lawyers, we don't know. And so the rule just said, you know, it shall not contain information that is privileged or confidential. And there's a lot of privileged information in these QI assessments. There's a lot of confidential information in these QI assessments because confidentiality just doesn't go under 827. It goes to any records that you have that are pulled from SAMHSA, that are pulled from SEMA, that are pulled from HIPAA, right? There's a lot of different confidential information that the QI may be gathering for these reports. And so however you guys do that now, sometimes it's a county council that does it, sometimes it's a supervisor that does it, sometimes it's the court that does it. But however that happens in your county, we just have to make sure that whatever information is redacted prior to it going out to the parties, right? Because we don't want, there's a reason we're redacting the information. We don't want that information to go out to all the parties. That doesn't mean you as the probation officer won't have the original assessment, right, in your file. It'll be in a confidential packet in your file, so that someone who comes under 827 and wants to review it, they can't review the confidential information. But that redacted information will go to the court. The case plan requirements will go to the court. And the tribe, if it was an ICWA kid that the tribe was conferred, a statement of if someone objects. Now, I get this question a lot. How do we know if someone objects, right? So one, the child's not there. You would think maybe that's an objection. Or two, like during the CFT process, that'll probably come up, right? Someone, if you're having the CFT, mom may object, uncle may object, someone may object. Now, that doesn't mean they have a say, right? Only parties, which we'll talk about in a minute, which is my little card here, get to formally object. But if you know, just from your dealings with the family, that someone's not in agreement, then you just need to put that in the report just to give the court an idea. Because if you're asking for the court to approve without a hearing and uncle objects, that's different than asking to approve without a hearing if mom objects, right? So depending on who you are, it makes a difference. So they're supposed to submit the form themselves, the input form. It's an input form, but you can put a formal objection on it. You have to give it to them. It's mandated that you give it to them. But there's a lot of things that our families may not know how to fill out forms. And they may not know how to get those forms to the court. So if you just in your regular sort of practice know this information, just put it in the report. It'll make everybody's life a little bit easier. And it will make sure that the court knows what's going on with the family. But you don't have an obligation to fill out that form for them and submit it to the court. You just have an obligation to put it in there if you know. Anything else? Okay. Okay, so we talked about this, that the report must be served on the parties no later than 7 calendar days before the hearing. And we're gonna get into timelines. That's a little bit tight, right? So our timelines with FFPSA are pretty tight between when the QI assessment's done and when the report gets to you and then when it gets to the court. And then there's that 10 days if you want it without approval of a hearing. Has any county done a local rule to approve STRTPs without a hearing yet? Okay. You can do a local rule. There's just some things that have to be on it. It just makes it really, really hard when the timelines are so short to be able to do that. Okay. So this is the input form that we were talking about and that only parties can object. So in juvenile justice cases, there's only like the kid that's the party and like the DA that's the party, right? But in our rule, we also have like the parents as a party, right? Because they're gonna want a copy of the report. So even though they're not formal parties in juvenile justice cases in general, they're considered parties under the rule of court. So you have the parents and their attorneys of record or the non-minor dependent parents, the legal guardians and their attorney of record, the child, non-minor dependent, and their attorney, and the child themselves if they're 10 years or older, the Indian custodian, and the CASA for kids under 300 and 450 jurisdiction. So those are the definition of parties under the rule. So like I said, the statute didn't define them, but they're defined differently for 300 and 602 cases, but since FFPSA applies to both, we just defined parties in our rule.
What is the regulation regarding if you've been in an SRTP, ran, and then you started a whole new QI, looking for placement, and that new placement wants to see the QI from under placement?
It's a really good question. We'll get there. And I don't quite know the answer to that question, so I'm probably going to talk to my CDSS colleagues. But these are the questions that are coming up.
Lisa's
Just so you know,
she's here
I know
right now.
Lisa's like, great. I really liked you guys, but now not so much. All right, so here's the JV 236 form that we talked about the objection. There is a box that's required to for you to check if you want it without a hearing, right? This is just to notice people, like we're gonna be asking to not have a hearing. It's mandatory. We talked about that. Okay, so what does this look like? So this is just a little flow chart for you because for me, it makes it easier for me if I see it sort of vertically, like where things happen. So we're talking about like when the child's placed, right? The court process, which may be different than, I mean, if you've got your act together, cool, and you do the QI assessment like way before the child's actually placed, that's awesome. That doesn't seem to be happening. That doesn't seem to be the normal practice in the state. It seems to be happening either close to when the child's placed or when the child's actually placed. So that's sort of what this is. So the child's placed, and then within 5 court days, you have to let the court know, and the court sets the hearing within 45 days. And then with 30 days, the QI assessment's completed, and then the QI assessment is sent to the agency, and it has to be redacted. So that's around day 35. So that's like 10 days before the court hearing. You get the report, and then it has to be redacted, and then it has to go to the court 7 days prior to the court hearing, 7 calendar days. So that time frame between when you get the report from the QI and when the report goes to court is really tight. It's really tight to do what you need to do. Yeah. This is for when you're asking when you're going to have a court hearing. Yeah. So if you're going to have a court hearing, it has to be 7 calendar days before the court hearing.
So the reason why they do that is because if you're going to have a hearing, people are going to be there, right? And they can say, I don't agree with this, or I object, or I don't. But you have to give them extra notice if you're going to try to do it without a hearing so that they do have the appropriate time to file the form or give the information to you so you can include it in your report.
But technically, 7 calendar days and 7 court days and 10 calendar days are essentially the same thing. If you think about it from just looking at a calendar, what that would be. But so the time frame just is really tight to do that, to get that report, write your report to the court, do the redaction, and then get it to the court before the court hearing. So things, yeah. Go.
What are you redacting from the QI? I mean, we're giving it to the attorneys and the court, and we're redacting something?
So the QI assessment, according to the rule, can't have any confidential information in it. So any of that confidential or privileged information should be redacted prior to it going to the court. If there is any, I don't know, your QIs might be great and not have any confidential or privileged information in the assessment. So I think, what we're saying is anything that's privilege, like attorney-client privilege, right, from the kid or the therapist, or anything that's confidential under another code section, right, that's not discoverable under 827. So things like HIPAA, things like SEMA, those things would need to be redacted from the QI assessment prior to going to court because you don't necessarily want the parents getting all of that mental health information about the child. I mean, there might be other people there's a long list of people under 827 who have access to the court file and who have access to the probation and child welfare file. So they just want to make it clear that what the information is giving to the court is the information it needs to make those decisions, and we're not adding extra layers of information that we don't need. And the court doesn't want it either.
I fully understand, but I don't know, we're just little POs. How are we going to redact a report that the judge wants to see? And they're going to come back at
Okay. And if you do and their attorney is not objecting to anything in the report, then, okay. But I know some attorneys who do, and I know some courts who are actually limiting the information the QI gets in their waivers. Go ahead.
If I can add to that, I think that piece about how the qualified individual is framing the information is really important. The State Department's Healthcare Services and CDSS are working on guidance to make really clear about the releases of information that need to be in place and the conversation around how the information from the assessment process is going to be used and with whom it's going to be shared. But our interpretation of the federal guidance is that the information is supposed to be shared with the court, and we're just requiring that there is consent and a release of information in place. But more guidance on that is coming.
So some counties are actually doing that where they have a release of information so that the child or the attorney is signing that to say, yes, you can include that information in the file. I mean, just think about it this way. Would you want everybody to know what medication you're taking, what you told your therapist, stuff that would be privileged? You have a right to invoke privilege. Just because you're a kid doesn't mean you lose all your rights and your privileges. So,
Yeah, so I would just say that some counties are more conservative, and the court is actually limiting the release of information that the parents are signing or whatever information the QI is going to get from the records, because they are just being more conservative. And then some have another process where they're using their county release of information forms to do that. And I think the practice is to use whatever county releases of information you have currently, and then the state's working on a universal one to make sure, because if you think about it, like even in your practice with service providers, a lot of service providers have different releases of information that people have to sign, right? And so it's hard to get everybody to agree on the language for one release of information based on what their requirements are under the statute or under their ethics code and their ethics regulations. So the state's trying to come up with one that behavioral health agrees with, CDSS agrees with, the county councils agree with, the courts agree with, that everybody agrees with.
and that's why we don't have it yet.
Yes. That is that's legally correct and accurate, that people can sign so that we can make sure that the information is protected and it's the correct information that we need. So that's when I talk about redacting, it's that. And like I said, there's some attorneys that are very, that will get this, and there's attorneys in Los Angeles that will get it and they will redact. And they will tell the court they need to pull the report and do it and then give it back. It just depends on what county you're on and how aggressive your attorneys are and what information that they believe is privileged and protected with the court. Yeah.
I appreciate confidentiality, and I don't have the QI report form memorized entirely in my head, but I got one section that's got mental health, and I got
Right.
one section that's got any assessments, and I got one section, I mean, if we restart redacting, everything is confidential in there, I'm not sure what part we're giving the judge.
And you're right. But all of those should be, they shouldn't be the assessment itself, right? Those should
We
be,
want the recommendation, the last sentence that has nothing confidential.
what we want the information, but we want it to be summarized, right? We don't want the full assessment and all the tools and all of the,
So that summary is in our memo, in our report.
right, that summary.
So leave the QI report out altogether.
Well, the QI report has the summary, right? So aren't you just attaching it to your report?
Yes, but you're saying redact that.
I'm saying that you can provide the summary. What the QI does and the information in the QI report is a lot. The QI does a whole mental health assessment that the court does not need. No, we don't need that information. The attorneys don't need the information. Well, the attorneys can get the information, but the court doesn't want it. They just want the assessment of like the long-term and short-term goals, what services the child needs, where they're going to get these services, and if this placement meets the level of care, right? Those are the things. Yeah, go ahead, Lisa.
There's a lot more that goes into the qualified individual assessment that isn't supposed to be articulated in that assessment report. So it really is supposed to be a synthesis of the comprehensive assessment, and we are working on some training also to help qualified individuals navigate that. But specifics about the dosage of medication and the specific diagnoses, and instead giving that bigger picture synthesized summary in the assessment report. They have a lot of documentation that backs up that assessment report that isn't given to the court.
Right. The court does not want to see all of that. They want to see a summary that will give them the information that they need, and then we're good to go. Again, if the attorneys, believe me, if the attorneys have a problem with the information in the QI report and they think it's confidential or privileged, they will let you know. And they will pull that report and they will do what they need to do. Because there's sometimes the kids don't even want their parents to know, right? There's some things that the kids don't want their parents to know. There's things that kids feel comfortable telling the QI or their therapist that they don't feel comfortable telling their parents. So those are the sorts of things that happen. When you do 827s in general, I don't know how many of you have those in your county, that people file 827 petitions to get reports. Like, someone redacts those. I don't know if you know that, but someone looks through those files and redacts them before they give them to whoever it is. It could be the court, it could be the county council, it could be the attorney. But someone does that. So whoever that is in your county, I would just find out who that person is and know who they are in case this comes up for you. But it sounds like in some counties it doesn't come up, and that's great. So that means the QI assessment is being done the way it's supposed to be, which is just the summary of information that's coming to the report. It was just very important for the Family and Juvenile Law Advisory Committee of the Judicial Council to say, we don't want this confidential information. We don't want it. We want to protect the kids' privacy, and we don't want it. We think we can make the decision based on the summary of the assessment. And if we need more, or if the attorney needs more, right, more importantly, if the attorney needs more, the attorney can get that information. And they can tell us, the court, what we think it should need to make the right decision. And we're going to get into privilege a little bit later because the attorney basically has privilege. So the attorney can get anything they want from the QI. And they can get the assessments, they can get whatever they want from that. And so they can really get that information and give it to the court or redact it or do whatever they need to do if they feel like the information in the QI assessment is not accurate or adequate. Any other questions? I don't want to this is a really important topic, so are there any other questions about that? Okay. This is the time frame for approval without a hearing. You can see it's almost the same. And then, except you have the 10 calendar days before that, and that your court can adopt a local rule to make this process easier. Some courts have good local rules to make processes easier for their county, so if you have one. What's happening now is because the timeframes are so tight, their courts are just having hearings. Because the timeframes just are so tight, it's by the time they would review it and not have a hearing, it's 2 days. So they're just keeping it on calendar because everybody's there. And they don't then have to say, I'm approving it, and then taking everything on a calendar for a 2-day thing. It's a lot of work when you have a hearing in 2 days.
How many of you have actually done a contested STRTP hearing? Anybody? Okay, that is mind-blowing to me. But it's happening everywhere where they're sailing through and they're not doing contests on it. But theoretically, an attorney could cross-examine the QI on anything they used if they don't agree with the assessment. So, yeah.
I think this was mentioned before, but I want to be clear for our county.
Mm-hmm.
If we have a situation where all parties, the CFC, IPC, the attorney, district attorney, and the defense attorney, and the judge all say STRTP is appropriate, but the QI says it's not. My question is, does that just mean it's a non-fed case, or does that mean it's an all county dollar case?
I mean, it's a non-fed case because the QI said no. I mean, I think if the QI assessment's done within 30 days, right, they get that 30-day of FFP, but after that, it's all county dollars, is my understanding.
But when we say all county dollars through realignment, does that still get funded through CDSS and our local DSS, or is that then am I going to get a call from my local child welfare partner saying, probation, this bill's on you?
See, that's a funding question that I don't know about, but we have great people here in the front who aren't going to like me very much after this training.
Why don't we save the funding questions till the very end so that they can get psyched for all those questions you're
And
going
they
to have?
can ask their colleagues.
Yeah, exactly. Yeah, there you go. I know, there's
There's-
texting and
see
emailing
texting
happening
and
right
email
now
happening.
before you're it's magic is happening at CDSS right now.
To answer your funding questions. I don't know. We don't do funding at the Judicial Council. You might hear that. we don't do money. But anyway, are there any other questions right now?
Okay, we gotta get moving.
Oh, we got to get moving. Okay, I have to stand up. Sorry.
Okay, you go, girl.
All right.
That, you can use that. Like,
No, let me use the lectern so
Yeah.
then I won't get yelled at. Okay. Who gets notice in the report? Okay, so we talked about notice. We talked about these are the people. The parents who are not usually parties in juvenile justice cases, but they do get the report. And the attorneys of record, the legal guardians, the non-minor dependent, the Indian tribe, and the CASAs. And one of the reasons why we put parents in the rule is because really this is sort of a foster care case, right? Because the child's in an STRTP. So it's not your typical sort of juvenile justice case. This is really a foster care case where the kid's in the STRTP. Okay, this is a proposal. You guys might have seen it. There's 27 forms in this proposal. So I know you guys read it all very, very carefully. But there's a proposal from the Judicial Council to change some of the rules and forms. One of them is to add who would get notice. So the non-minor dependent guardian ad litem and legal guardian. So if you don't know what a guardian ad litem is, it's if a youth doesn't have capacity to make some decisions, the court will assign a guardian ad litem. And that happens in some cases, so they would get a copy of the report. The county council, we neglected them. The district attorney also neglected them. The social worker and probation officer, the two most important people, right? So anyway, I think this will probably go into effect, but we don't know yet. So if it does, it goes to the council September 20th, and if it gets approved, these would be the new rules as of January 1st, 2023.
Let me just say real quick, one quick thing about privilege too, is think about those mean old district attorneys and what they do, right? They read all the old probation reports, they look at all the old stuff. That's why confidential information should not be in there. If it's not relevant to what's before the court at the time, it shouldn't be included, and the kid's privacy should be protected.
Is that the same for 300 cases? Because it seems to me 300 is a bit different.
In what respect?
Well, like, parents are parties.
Yes, they are parties.
So,
So they would already get a copy of the report.
They would.
Right. Yeah.
Yeah,
Yeah.
they would.
We're talking about probation.
We're talking
yeah.
about probation. These are probation officers here.
But yes.
I'm teasing you.
But you, as a social worker, would get a copy as a probation officer. We just neglected. You're already parties, or so in child welfare and probation cases, we just added that to the rule. Who can object? So we were talking about this, right? If it's the uncle, they're not a party, right? But who are the parties? It's the parents, as long as parental rights haven't been terminated, or non-minor dependent parents if they're in reunification, the legal guardians, the attorney of record, or the child if they're 10 and older, and the Indian tribe. Proposals of who can object starting in May, or starting in January. Maybe. The district attorney, the captive GAL, and the non-minor dependent guardian ad litem. For those of you who don't know what captive GAL is, it's a federal law that requires that a child get an attorney that talks about sort of their best interest. In California, we have a hybrid model, but sometimes a child needs two separate people, an attorney and a captive GAL. That's very rare, but sometimes it happens, and someone pointed out that we didn't have that, so we're gonna maybe add it. Okay, lots of forms,
Talked about all the
because we
forms.
like them. We talked about all the forms, the JV 235, the JV 236, the proof of service, and the JV 239, which is the court's findings and order forms.
And by the way, I know I was making jokes before about mandatory and optional. The Family and Juvenile Committee of the Judicial Council is judges, it's county council, it's a whole social worker, like it's a whole mix of people. And they put a lot of thought into whether a form should be mandatory or optional. Because this is a new procedure, because it's kind of complicated, because we haven't done it, that's why 4 out of the 5 are mandatory. So I know I was being a little facetious, and I'm using that word because they used that in the movie this morning. But yeah, they put a lot of thought into it, and they're also putting thought into when the counties want to do their own thing and not have to use mandatory forms to do some of this stuff.
Right, so the forms that we're talking about now are mandatory, but we asked a question when we circulated the 27 forms for comment just in last month about whether they should be mandatory and optional, and we got comments back from both. Some people wanted them to stay mandatory, some people wanted them to be optional. So we'll see what the committee decides in terms of how that will proceed. But we asked the question because we know that sometimes mandatory forms are not the easiest or the funnest to fill out. So the things that are proposed changes in the forms right now. So the JV 240 is our notice form. And so there's a recommendation that it be amended to require the JV 240 to be served on parties along with the report. There's also an amendment on the notice form for where the child's placed. So we asked whether we should have, the actual location of where the child's placed. And actually, there's controversy about that. Some people want it and some people don't, so we'll see what happens. And then they want to know, right, if they're going to be there or whether it's going to be confidential. The JV 239, which is the order form, the judges wanted sort of a list of reasons why they may not approve the placement. So there's some check boxes about why they may or may not approve a placement, so they don't have to write it all down. And then, sort of updating the JV 236 to provide clarity about when you wouldn't want to have a hearing. And then there's 2 more issues in the AB 153. You all thought it only talked about FFPSA. Got news for you.
But wait, there's more.
Doesn't. It talks about 2 other things that are not FFPSA related, but they will go into effect January 1st of 2023. So I thought I'd give you a preview and an idea what that looks like. Can you grab those? Thank you. Okay. So the first one is for a child who's 16 years of age and older, whether the social worker or probation officer has identified a person who's responsible for assisting the child or non-minor dependent in their post-secondary education. Who knew that was going to be a requirement in January 1st of 2023? You didn't? Well, now you know, and it's proposed on the form. So if you'd use judicial council forms, there is a finding that the child's 16 years and older and pursuant to 16501.1, which is the code section that requires this, it's your case planning section, that there is a person who has been identified for post-secondary education, the name of the person and what supports they're going to give, and how they're going to assist. So that is new, and because the law told us to, we will have rules and forms by January 1st of 2023. That is one thing that's in the cycle. And the second one is reproductive health rights is now going to be something required, a finding required by the court. Who knew that one? Oh, some people did know that one. Okay, that's good. So this one is that for youth 10 years of age or older, and they're in high school or middle school, and the court has jurisdiction, that it has been verified that they have received comprehensive sexual education. They've been informed of their reproductive health rights, and they may access age-appropriate information. They've been informed in a developmentally appropriate way, and they've been informed how to access the requirements, or they haven't, and the agency is required to make that information available. So this was part of SB 89, I think, like a couple years ago, but it was never required to be a court finding. It was just required to have something to do and able to be done in your normal case planning practice, but now it's required. It's going to be a finding that the court has to make. So that information will now have to be in the court reports. So lucky for all of you. And what I will say about the sexual healthy development education, I can't remember the exact name of it, it's not like an opt-out. Like, at school, and if you're the parent, you didn't want your kid to, like, have the information, and you could sign the release form, and then the kid didn't have to take part of it. Like, if the kid is, there has to be something that's provided, and if it's not provided at the school, then the agency has to provide it. Okay. Questions about any of those two things that I just threw at you in a few minutes?
Okay.
Okay, we're gonna practice now. Okay, we have Bonnie and Clyde, because I'm so creative and that's all I could think of. So, Joan's gonna do Bonnie, I'm gonna do Clyde, and then we're gonna wrap up with some information about what to do in permanency. So I'm gonna turn it over to Joan.
So we're going to kind of whip through these because there's a couple other things that we want to cover, make sure that we cover with you at the very end. But Bonnie and Clyde, you guys all have copies of this in your handouts. Were arrested for a 211 while high on meth. I know, shocking. At the detention hearing, Bonnie's mom and stepdad appear and Clyde's grandma appears. The court keeps both youth in custody pending adjudication. What would you want to know at this point for your social study report and recommendations? Just shout them out. Where are they going to live? Say it again. Where's the father? Does grandma have guardianship? Does she have legal guardianship? All these are great questions. What else? How about what? How are they doing in school? Previous history. Are there CPS referrals, prior probation referrals, informal probation? Yeah. Okay. So one of the things, family members, absolutely. So one of the things I saw recently in a county was they had county counsel on the record at detention hearings. They went through, they asked the kid and mom and grandma, whoever was there, to the 5th degree, their relatives, and whether they had any Indian ancestry. It was just like done. Right there. Oh, you have a cousin? Where did that cousin live? How long ago did that cousin live? When was the last time you had contact with that cousin? Blah, blah, blah. Sounds like it took like 5 minutes. It was super easy, and you got relative stuff and ICWA. By the way, ICWA does not apply to 602 cases, right? How often have you heard that? Like all the time? Well, guess what? Every single case you have, you need to inquire whether that's an Indian child. And that's because of when they end up in foster care. They are entitled to culturally appropriate services while they are in foster care. Okay, so let's move on to the next one. All right, so they're having a CFT because we are one with CFTs. Bonnie, stepdad, aunt, hall therapist at Bonnie's request. She's got some strengths. She doesn't have any prior history. Her aunt in Arizona wants to help. She tried substance abuse treatment one time before through insurance, but she relapsed when she started to hang out with Clyde. Bad influence, that Clyde. She had a bunch of unexcused absences and tardies from school. She started with marijuana, blah, 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 blah. Okay, other siblings in the home, so mom and dad had sent Bonnie to live with the aunt because they don't want that influence for their little darlings. What's your recommendation? What's the recommendation from the CFT? What do you think is going to happen? There's no wrong answer to this question, by the way. Wraparound. Great. What else? Who else are you going to explore? The aunt. Okay. And if you want to place with the aunt, what do you have to do? Wait, say it again. There was some. ICPC. Okay. Check her out. Make sure that the agency in the other state says, yep, aunt's okay. Do a background check. Do what you got to do. Okay. What's ICJ?
That's the Interstate Compact for Juveniles, when they're on probation, the local county supervisor.
Yes, correct. So at that point, we were just talking about placement, but you are correct. Okay, so let's see. So we're going to do a little exercise here. CFT, they decided that Bonnie was going to live with the aunt. So the adjudication is set for the 14th. The court finds the petition true, declares Bonnie a ward, and orders terms and conditions of probation, releases her from juvenile hall because she's done so well there, and then she doesn't go to school and fails a drug test. Okay, and so then a probable PC warrant issues. Then she's arrested for aggravated assault because she's moving up the food chain. Then they have another CFT, and the STRT is recommended on 4/20. Okay, those of you that are laughing, that's just kind of like, okay. I won't even say it. My college-age daughter would have something to say here. Okay, and on April 22nd, the court actually orders foster care placement, and packets are sent to placement. And then on May 1st, Bonnie is placed at Happy Trails STRTP. Because who doesn't want to go to Happy Trails? I mean, come on. All right, so questions. When is the QI assessment made? Loud. 4/22, who says 5/1?
420, I have 420, which is the CFT held and STRTB recommended. 422, when the court orders foster care placement. Are you talking the referral or the referral?
We're talking about the referral.
Oh, the referral?
Yeah.
We would make it prior to 420 so that the QI could attend our CFT.
Well, that's because you're super organized, apparently. That doesn't happen for everybody, but
Who does that?
YOLO,
QI attender,
which is great. I mean, if you can have the QI attend there, that's great. But the answer is either 4/22 or 4/20. I think you can make an argument, or beforehand. If you're Imperial County and you do it ahead of time, because they're in the back. Okay, when's your IPC held? Prior to placement. So between what and what is your IPC going to, between what dates? 4/22 and 5/1, okay? Your IPC is going to meet. When do you have to notify the court of the placement? Bonnie's placed on the 1st, but the judge ordered foster care placement on 4/22. 5 days of? 5/1, exactly. May 6th, that's going to be your date that you got to give them, okay? When's your QI assessment due? So one of the charming things I heard recently is QI saying, well, I'm entitled to 30 days. So if you don't tell me until later, then I get my 30 days from the day that you tell me. Thank you for playing. That's not the way it works, okay?
Place the child in the STRTP. Our county is looking at the assessment has not come back. They're treating that as an emergency placement. Is that correct?
Yes. Okay. When's your court report due? You're going to have a hearing, by the way. FYI. When's your court report due? 7 days prior to the hearing, which would be June 8th. Okay, and your court hearing, okay, so I know I was making jokes about 4560, okay? You want your judges to set the hearing within 45 days, because then if it does need to get continued, or the kid's sick in juvenile hall, or whatever happens, then you got some time to play with, okay? This is the $64,000 question, and I have a Starbucks card, if somebody can get this right, okay? What is the next court hearing after the FFPSA hearing? Let's presume that the court approves the placement. Yes. Okay, we got one person answering here right now. Go ahead. Pre-perm hearing, correct. What date would that be? What's the last day you could hold it and still be timely under Title 4A? Okay, you have to give me a date. You don't get to do the 6-month thing. Because I had to do the same thing where I'm like, let me count on my fingers. Yes, thank you for playing. Come get your Starbucks card. Let's give her a round of applause. Okay, and you know what, and I know I'm joking about this, but I'm really serious about these time frames for pre-permanency, permanency, and post-permanency. And these are not easy, okay? That's why you have JIRTA attorneys. That's why you have UC Davis that has an entire site, which is on your list of references that Mary Michael did for you, that answers all sorts of questions about FFPSA. Because you think you're original. You ain't. Okay, somebody's already asked that question on there, and if you go, it may be a little different than your question, but it'll guide you at least in the right direction. Okay. I'm going to actually skip ahead because I want Mary Michael to be able to take care of Clyde, because Clyde has issues. So,
You want to do Bonnie's attorney? That one?
yeah, let's skip ahead to that one. Okay, so we're going to talk about privilege for again a second. What does the attorney get? Who holds the privilege for the kid? How many times have you had mom say, it's my kid? I'm invoking the privilege. Okay? Thank you for playing. You have an attorney. The attorney's ethical obligation is to the child, and they are the one who hold the privilege. Okay? So they get everything. They get everything. Yeah, we're going to skip ahead on this one because I want you to be able to do Clyde. So go for it.
So Joan said Clyde was a troublemaker. I disagree, but whatever. So Clyde's 16. He's living with his grandma on and off for his entire life. He does not know his mom or dad. He doesn't know his dad and his mom's house die about twice a year. And grandma's home is also an aunt and her two children, ages 10 and 12. The petition alleges that Clyde was high on meth, but he tested negative for all substances. And he said that Bonnie was the one who talked him into the robbery. Just saying. While Clyde is in custody, one of the cousins tells him that Clyde had sexually abused. One of the cousins tells her mom that Clyde had sexually abused her. When confronted, Clyde initially denied the allegations, but then said it was no big deal. On January 7th, the petition was amended to add a PC 288A. The court detained Clyde in the hall pending the next hearing. On January 14th, a CFT was held, and it was agreed that aunt and the cousins would move next door.
Which sounds like a great idea to me, but you know.
And that's a typo. And Clyde would go home with services from the community. At the adjudication hearing on 121, the court decided that there were not enough supports in the community to support Clyde's treatment in order to put him into an STRTP for sex offenders. What do you do first? Besides spell door instead of store, which was my bad. QI referral, JSO assessment. There's no wrong answer. I mean, there's a lot you have to do in this case, right?
You need help from another probation officer. You know, you got a lot of tasks to do.
You have to have an MDT for the kid. Okay, so timelines. Clyde was placed in Honey Farms STRTP. And the court set a hearing on March 18th. On March 1st, the QI assessment is filed with the court recommending against the placement in Honey Farms STRTP. On 3/16, the court approves the STRTP placement. What is hearing is next, and what is it called? Pre-perm on. Oh, whoops, we skipped a slide. That's my bad. Okay, we'll go back. Sorry, you're right, it was a pre-perm. You get a Starbucks card anyway. Clyde, 16, had lived with his grandmother on and off his entire life. He does not know his dad. Oh, no, we already went over this one.
Yeah, we did.
Oh, so it was July is the pre-perm hearing. Yeah, the court holds the pre-perm hearing. Clyde's completed, so on January 21st of the pre-perm hearing, Clyde has completed his program, and in November, he was actually placed on an extended visit with grandma. Which happens, right? Because we all get through sex offender treatment in like 6 months. Okay, so now we're gonna talk, we only have, this went fast. We don't have that much time, but we're gonna talk about some permanency options for Bonnie, who's 15.
Okay, so you've done all of this work, and the kid is at an STRTP. It's a good placement for the kid. And then because you've done such a fabulous job as the probation officer, and the court has also, and the QI has, the kid does great in the STRTP. Okay, so now what are your options when Bonnie gets out? I'm gonna ask you a trick question. Who knows what an APLA is? Okay, honey, you should all know what an APLA is. Another permanent plan living arrangement. Can Bonnie go to an APLA? Okay, you just want another Starbucks card. You are correct, she can't. Kids have to be 16 or older before they can go into APLA. Okay, because we don't want kids opting out of permanency just so they can go into an independent living arrangement. Okay, let's do, so Bonnie's the one with the aunt that lives in Arizona or wherever it is she lives, okay. What are the 4 places we can have Bonnie go after she gets out of the STRTP? Mommy, I love you. Where's she gonna go? Home, she's gonna go home. Score, right? That's the most permanent option. That's the one that we're looking for as long as she can go home safely. Okay, all kidding aside. What's number 2? Relative, who said relative? Good job. Relative, other relative, or NRFM, okay? We're gonna talk about that in a minute. Okay, we got 2. RFA, excellent, okay, and then we got one more. We forgot about somebody. I can't think of a song that has Arizona in the title, so yeah. Winslow, Arizona, such a fine sight. Yeah, so we're gonna go look into the aunt, and we're gonna see whether she can go to the aunt, okay? We gotta kind of whip through the rest of this because we're running out of time. I am not gonna cover aftercare requirements. You know why? Because there's a whole session tomorrow afternoon about aftercare requirements for STRTP. The main thing I want you to know about STRTP aftercare is there's something called super wraparound, fabulous wraparound. I don't know. There's some like Uber wraparound, super fabulous wraparound you can do, and you can get extra money for that. But having said that, aftercare services are voluntary. The kid and the family don't have to participate. I mean, you could probably make it a condition of probation, but that would be kind of being punitive before you're being therapeutic, which would probably not be great. Okay. But yes, the options that you have are to return home, dismiss the case, right? Kid goes home. Legal guardianship, you also dismiss the case. Adoption or tribal customary adoption, you dismiss the case. Placement with a fit and willing relative. This comes up all the time. I love Joni, but I don't want to be a guardian. But I want her to come stay in my home because she's my relative, and I love her. That is a permanent plan, okay? Staying with a relative. APLA, we just talked about. Extended foster care, if you are a single jurisdiction and it's still not safe for Bonnie to go home, what do? We transition her to 300 status, okay? Let's see if there's anything else really quick you want me to cover in these.
Nope, I'll go ahead. So in our last couple minutes, I just wanted to talk about the permanency. Yeah.
This session ends at 4:45.
Right.
Oh, okay. Just wanted to-
There's just more that we have to talk about, Stephanie. We don't want to shortchange the permanency options. So we talked about return home. So things to consider. Somebody mentioned it earlier, fathers, right? Parentage. So why? And the court has a duty to establish parentage, but why is it so important to establish parentage and know who the dad is?
I like how all the guys are like, I don't know.
Oh. Right. The whole side of the relatives. But you know what else? You have to pay for kids to stay in the hall and to pay for foster care. And if you don't have a parentage thing, well, you don't have to pay for services, but you still have to pay for time.
No, you don't, actually.
You don't anymore?
You don't pay for
All
juvenile
right,
hall
fine.
time.
You don't have to pay for juvenile hall time.
There
You
was
used to
that-
have to pay for juvenile hall time. Fine, you don't have to pay
Because
for
they
it anymore.
tried that, and then they...
It didn't work.
No, they passed
And
a
there's
statute
child
that said they
support
didn't get to do
that has to be paid for children who are in foster care placement settings. That still has to be paid for, and for services. But that you can go to a child support agency to try to get that done. But they'll get something from child support that comes to them. And so there's a JV 500. It's a mandatory form. There's a JV 501, which is findings and orders for parentage, and then there's JV 505, which is statement for parentage. The JV 500 is really easy. You just send it to the child support agency. And it tells you whether there's a parentage order on
Yeah.
file.
Back row.
Yeah.
Yes.
I just have a comment, since the passage of all the new legislation that eliminated our ability to charge for juvenile hall fees, that kind of money.
Right.
Our local child support agency determined that our youth in foster care and probation were no longer going to get charged child support.
Oh, well, that's good.
So the law did change a couple years ago, and there's been some recent case law too about you can't charge parents or kids for services while they are on probation. You cannot charge them for juvenile hall time. The child support thing, I don't really know that. I don't really know about that, to be honest with you. Well, I originated from San Mateo County, and I think they did. I think they, at least on the child welfare side, they used to, but I don't know if they still do on the probation side. No? Ms. Waters says no. Okay.
So there is a child support thing that goes. Now, whether the county does it or not. Right.
Every time it was an absent parent, and we collect on an absent parent, whether it be the mom or the law changed, what, a few years ago, and it doesn't matter. A parent can put their kid in foster care, say, I don't want my child. There is no more absent parent money that we can go after if the kid's in foster care.
Okay.
That was my understanding when I went I don't know, several
Years ago.
to
Because there was statute change that parents had to go and talk about their ability to pay, right? And their ability to pay for services and their ability to do reunification services, and that's why everybody was going. And if there was no ability to pay, then there would be a zero bill, right, for that. So anyway, parentage, that's an issue. The forms are here, the JV 500, the JV 5, they're all mandatory. They're really easy. You can find out if there's a dad. And you can find, and if there isn't, the court can make orders if there's a dad.
So I'm gonna put a little plug in. I do not get a kickback, just FYI, okay? For Seneca Family Agencies, $30 a parent. They will find your mom and your dad. $30. They do an extensive search, they do social media, they're amazing. And once again, I don't work for them, I don't get a kickback. But when you think about your valuable time that you're trying to find parents or, find what's going on, and if you can pay somebody to do that for $30, that's an expert that does it all day, every day, I think it's a good amount to spend of your county dollars.
Okay, so people don't, when we talked in the beginning, we talked about what it means to be a ward, for the court to take jurisdiction, the court to make a child a ward in a foster care child or place them in an STRTP. It means the court takes custody of the child. The court literally takes custody, legal custody of the child. So when you're returning the child back home, if there are two parents and you want mom to have primary legal custody or you want dad to have primary legal custody, there are custody orders, the JV 200, they are mandatory. They talk about who gets custody, who gets to make education decisions, what the visitation is like, all of those things which you have access to, so you don't just dismiss the case. You can actually dismiss the case with formal custody orders that deal with some of the things that may have brought the kid, or contentious things that brought the kid into the system beforehand. So it's really important when you're transitioning kids, if they're gonna go home, think about that. Think about where the court has to give custody back to someone.
Just like you do in child welfare cases when you do, a final custody order when dependency is dismissed.
So you have the forms, they're mandatory, they get filed with family law. So the parents will get a copy, they'll get a family law case number. If they want to go change custody, they can do that in family law. They don't do it in juvenile, they do it in family, but then there's a formal order of who has custody of the child and what orders are being made.
So we do the 200 though, right?
You would do, or the attorney can do it, whoever the court wants to do it. In some cases, in some counties, the attorneys do them and work out the settlement agreement of visitation and stuff like that. In juvenile delinquency court, yeah, you would do the custody orders, either you or a mediator or the attorneys would do them, and return custody back to a parent, because the court's had it this whole time. Okay, legal guardianship and adoption. So in Clyde's case, he was with grandma who was not a legal guardian, right? So oftentimes, people will just return to legal guardian and dismiss the case. But that doesn't solve grandma's problem because she doesn't have custody of the child, right? So things that you can do is file the JV 320 and do guardianship of the child to grandma, right? So when the court closes a case, remember, the court has had custody this whole time of this child. So when the court closes the case, it has to give custody back. It can give custody back to a parent, it can give custody to grandma, and you can do a guardianship. Those are the letters of guardianship, or the JV 320, which tells the court that you're going to order, that the court's going to order a guardianship, that the kid doesn't want to be adopted, or other things. And then the grandma will have letters of guardianship. These are the letters of guardianship. All of these are mandatory forms. These are the letters of guardianship. The grandma has them. She can go down to school. She can go to medical appointments. She can go anywhere. She is the parent. So I don't know how many people here have done legal guardianships in juvenile justice cases.
Good.
1, 2. Okay. It's an option, and use it, because grandma may have her name on a Medi-Cal card, but if push comes to shove, grandma can't make any decisions for Clyde, because she doesn't have legal custody. Yeah.
Sorry, we have a situation currently, that a kid, both of his parents have recently passed, and he's been living with an adult brother. And can we just do this rather than making him like an RFA while he's trying to go through the process of guardianship, or something? Can we kind of take over and do this as an option?
Where is he now? Is he in? He's with brother. In a foster, is the court taking custody yet?
No.
Okay, so that's one thing. The court has to take custody, and then the court can do something with that and give it back to brother. But that's the first thing the court would need to do.
Make that all one recommendation then?
No, because you have to do a social study for the guardianship. So you have to do a report on the brother and all of that things. It's all in the code section about what needs to be in the social study about the brother. Yeah.
In a situation where mom has not, or mom has lost, parent,
Parental rights. Yeah.
then the RFA would have to take it.
Has the kid been adopted by another person?
Like, let's say if we inherited the need from CFS,
Mm-hmm.
and then, the parent lost parental rights. So let's say we're doing treatment 6 months out or so.
Mm-hmm.
We want to mainstream them back into community.
Right.
It could be a family member or a non-family member, then we can start the RFA process in that situation, correct?
Yeah, you can start the RFA. Yep. You can also, look for relatives, look for guardianship. There's also, I think there's going to be some code changes coming up regarding reinstatement of parental rights for kids who haven't been adopted for a period of time. So I think that'll be coming in January.
If the parent lost parental rights,
Mm-hmm.
we can't go to guardianship, we don't have to go to RFA, is that what you're saying?
No, you can go through RFA. I'm just saying that there's other things that you might. Well, right. So if the child's going to be in foster, you're saying the child came from CSF, so my guess is the child's already in foster care, and then has committed some crime, right? And so now they're done with whatever that crime is, so they're done with their hall time or whatever, so then they're going back into a foster care placement setting.
The push basically is not to return them back to CFS if we can avoid it, to rather go to an RFA.
Are you a single jurisdiction or a dual jurisdiction?
Okay, so you're going to approve an RFA and have the child go to an RFA placement. And the child's been where? In the hall? In an STRTP? Ah, okay. Yeah, so then the child can go into an RFA with RAP services or whatever they need. If you found another family member and that was appropriate and you felt like the case could be closed with a guardianship, you could do that. That's an option for you when you feel like we're at the end of the case and that the case is closed and you need to give custody back to someone.
You can either do legal guardianship or placement with a fit and willing relative.
Okay, because our understanding was if the parent lost rights, if we had another family member, we placed them with the family member as an RFA.
Mm-hmm.
Or another RFA family member.
Right. Right, you can't, they can be a NERFM, right, a non-extended relative family member, but they can't be like a bio family member because the parental rights have been terminated, right? Yeah, so, but there are certain circumstances and there are ways, if anybody has a child who has been adopted, who the bio parents have now cleaned up their act and like want to come back into the child's life and be custody, there is a way that you can reverse a termination of parental rights down the line if you feel like the parents are now capable of being parents and that this would be the permanent plan for the child. So the parents are never completely out, even if parental rights are terminated, if they would be an appropriate option for the youth when they come back.
To complement it even further, after they're 18, even if parental rights have been terminated, those parents could serve as a SILP for the kid.
Mm-hmm.
So real quick, we're going to talk about transition to 450, okay? Do you have to have a hearing before when the kid turns 18 to magically imbue them with your wand that says you are now a non-minor dependent? No, you don't. They magically get wanded, and they are there. okay?
It's magic.
It's magic. But they can stay at 602 if they have not fulfilled their terms and conditions of probation, or you can transition them to a 450, and then they are a non-minor dependent as a 450. Okay, really quick. We only have 10 minutes left, and you guys are so psyched. I know, because it's 4:35, and you're like, thank the
On
Lord,
a
we're going to get out of
Monday.
here 10 minutes early. But you're not, okay? Just FYI. Okay.
Because
so,
we have chocolate and gift cards.
Because we have chocolate and gift cards. Okay. So this half of the room is AWOL. Okay, you're not really AWOL, but you know what I mean. You're going to talk about AWOL. Okay? And this half of the room is going to talk about CFTs. Okay? So something that is near and dear to my heart is when kids are AWOL, they actually want people to look for them. Okay? So I would like you all to confab with each other, maybe a group of like 3, 4, 5, whatever, okay? And talk about creative ways you can look for kids when they are AWOL to bring them back to an STRTP. This half of the room is going to talk about you're at a CFT, and the kid says, I don't want to go to an STRTP, but this one is so perfect, it's Shady Pines or Happy Trails or whatever it is, okay? And you're thinking, this is the place. I want you to brainstorm about some ideas that you could proffer at the CFT to try to convince this kid that it's the right placement for him. All right, you got a whopping 5 minutes.
Got 5 minutes. I'm going to start the timer.
Do it.
You still have to answer the funding question.
For them to talk,
Yeah.
are you having one assigned to come up and talk?
Oh.
Because we're not passing the mics out.
No, I
So
know.
should they come up here?
You know what? It's really loud enough that I think everybody can hear everybody.
Really?
With the questions, we haven't been having any
The
problem.
audiovisual folks are saying, oh, we can't hear them say.
Okay. We can do.
Yeah. But they're still.
Oh. Well, that's why I tried to repeat the questions too. I tried to repeat the questions.
Yeah, no, you guys are doing great. Yeah, I just didn't know, like, if you're gonna assign and then one come up and share, or, I don't know.
Okay. I'm
Or,
probably
I
just.
mean, they can speak loud.
Yeah,
I mean,
They'll just have to get over it.
We would still have grandmas and
after
everything,
this,
but what
that's
often
it, right?
happens
Yep.
is that they just
how
refer
do
to
we even know? I guess my thing, because it's being
right?
recorded, so
They're like,
that's
oh,
why.
grandma,
Right.
that's where the kid was living.
He actually said that we could walk around with the microphone.
And then
phone.
the kid has the
Our
medical.
conference planner said,
No. That's why we didn't do it, because you told us we couldn't do it. But he said, like, if you're going to go questions or whatever.
because I told her, I was like,
Anything else, and they just are
brought
like,
it up twice, and she was like,
this happens all
no.
the time.
Because I guess
They turn around
the
with
same
it because
venue,
the kid's been there.
they've posted, they've
Yeah.
done a venue for another conference, and it came up with the same thing. So anyways, yeah.
Okay.
Sorry, because I didn't know until the last minute. That's why I shot you guys like last minute. I know it was at the end of the instructions, but I'm like, oh God. Because I thought we were passing them. I didn't know. And then she was like, no, we're not doing that.
I mean, it kind of makes sense, but what they did in the one presentation is they had the person with the microphone go around. Somebody from CPOC went around with the microphone to people.
Okay, not at general session.
No, at this one, at the education one that was before this. Okay, well, I'm not ratting them out. I'm just saying, like. There you go. Exactly. Yeah, exactly. You're like not establishing eye
I have
contact.
to see how much time we have. We have 2 minutes.
Okay, 2-minute warning. And if you're on your phone, please put it down so that you can confab with the other people in your section. Here's your candy, by the way.
Do you want me to cut this out, people?
I don't know. I'm gonna allow
I'm
Mary
not a very
Michael to
good
like.
shot.
Can you guys know? Oh, okay.
So did we do okay, Mom?
Huh?
Did we do okay, Mom?
Yeah, just gonna-
Oh, that's right. We had cards.
Oh, you and everybody else.
You know, because
Yes.
how can I say it? Being so technical,
I know.
sometimes we like.
I
and
hope
at
I
the end of the
I hope
day-
I don't get in trouble later on. But yeah, we have another card.
I have a card too.
And then just once again, once you guys are done, maybe I'll stand by because I might just tell them to go over there. And then there's a reception. I don't know if you guys are able.
There is.
Yeah, it's outdoors. Hopefully it's not too hot.
What do we do about getting parking validated?
Let's see.
Is there a thing?
Yeah, so you guys are covered. I should be able to get a pass.
Okay, why don't you figure out whatever we have to do for that? I have my parking ticket. I just took just a ticket when I came in. 30 seconds.
You're gonna be here, right? Like,
Tomorrow.
we're not-
Yeah.
you over to the person that should have the pass.
Okay.
Oh, I got mine for parking.
Yeah, what do you have to do for parking?
I got it.
What did you do?
I just went up there and they gave me a thing.
A thing.
Yeah, once you register.
Can you get me a
They gave me a
thing?
ticket.
Pass, they should give you one of those.
Oh, okay, I didn't get a thing. Can you get me a thing? Okay. Gotcha. We got you. I got you. Okay, guys, time's up because we don't want to keep you over.
Okay.
But I love the fact that everybody's still talking. I actually do. That's great.
I'm going to leave the Dove chocolate because mine says be fearlessly authentic. And I think everybody should have a good thing to leave the day on.
Okay, so who from this side of the room would like to tell us their best idea for looking for those little AWOL darlings from their Happy Trails STRTP? I did not, but thank you. It's on video. Okay. Okay, I'm sorry, I need to get your hearing checked, but there you go. Anybody have great ideas they want to share? And the reason why I harp on this is because A, kids want to be found, and B, it's part of reasonable efforts. You have to look for them, you have to include that in your report, you have to put it in there. Yes?
We actually had this recently from an RFA home, not an STRTP, but we started with the brother and friends, and then when those efforts went dead, we looked at Instagram and social media pages, and then because she had not contacted any of her friends or family like she usually does when she AWOLs, we actually got our sheriff's department involved and got them to get a ping warrant to try to track her phone because we were concerned for her safety at that point.
And did you find her?
We did.
Yay! All right. You got to catch, though. This nice lady is ducking for you. Okay,
went
so I'm
really
not
far.
joining the Oakland A's anytime soon. Okay, this side, who wants to volunteer? Yes. Ideas at CFT. The little darling doesn't want to go to STRTP. Okay, cool. We like that. Additional facts. Oh my God, I love their making up facts. So the
It should be small
STRTP is
farm
like
STRTP.
custom made for the kid. Yes. Okay, I think that's great. I'm not going to try to throw it. So come get it. There you go. Stephanie's going to take it. So this is also near and dear to my heart as a former juvenile justice attorney and as a former dependency attorney. How many times have you had a client that said, I don't want to go to the CFT. I don't want to have people talk about me in front of me. You know what I used to say to my clients? There's going to be a lot of decisions made about you at this meeting. So do you want to have any input? If not, I can tell them what I think should happen with you. But I think they'd rather hear it from you. Okay, so I think CFTs are the wave of the future. Most agencies have somebody who's trained in how to do them. Somebody asked me the other day from another county, is it okay if the CFT facilitator is from probation? How do we feel about that? I'm seeing nodding. Okay, I'm kind of torn. I'm not going to lie, because the PO can do stuff and has some power and control over the situation. So maybe it would be better to have somebody more neutral. Okay, other ideas about AWOL, real quick. Yes? Nice and loud.
Insta face chat.
What's Insta Face Chat?
Instagram, Facebook, Snapchat.
Okay, stop laughing at me over there. Okay. You just made up this, social media thing. It's Insta, Face Chat, Tweet, whatever. Okay. Does anybody's county not allow them to go on social media to look for? No, good, because sometimes that happens too, where they have some restriction on what you can do. Okay, one more. Come get your Starbucks card. And she was sitting next to me earlier, and she's very nice. Okay.
Okay, so I have a question.
Questions.
There was an issue about discussing the makeup of the CFT, and I think Joan, you had just said if the parents decide in the CFT if they're in reunification, and I think it's that the parents have input, right?
Yes.
Yes, they have
I
input.
must have misspoke.
The youth has input, everybody has input, and then the CFT, I guess, sort of decides, except that if they can't decide, then the court decides. So you put that in the report, and then the court decides. I have another great question here. It's not CCR FFPSA related, but I know you are all waiting for when judicial council forms for secured youth track programs are going to be released. How many of you are waiting for that? All of us are. I have no idea is the answer to that question. Right now, the Judicial Council is working on the secured youth track matrix that has to be put into place by January 1st of 2023, which we are hoping to get done by September, so it goes out for public comment, so you guys can all see it, comment on it, tell us what we're doing right or wrong, and then we will take that back and hopefully go to the council and train the judges before July 1st of 2023, so that you will have something to use. And then we'll talk about rules and forms, but that's what we're working on right now. So sorry, I don't have a better answer for you.
I did put everybody off with funding, but I'm sure Lisa wouldn't mind staying around afterwards to talk. No, I'm kidding.
She does have an answer to the funding question to whoever had asked it prior, so catch her on your way out. She really isn't gonna like me after this trip.
Thank you very much. You guys have been great.
You guys.
Thank you, everyone.